Good afternoon, dear colleagues. It's my pleasure to welcome you once again to our Boni. This looks a little bit different from normal. The reason for this is that I'm on holidays at the moment, and I apologize for everything which is not running well, not only content-wise, but also from a technical perspective today. All my fault. However, I think it is important to talk about the topic that I will cover in a second, together with my colleague Katerina Polychronopoulos. Katerina, just to introduce her briefly, is an American lawyer who received her Juris Doctorate in 2012 from the University of Illinois. And before moving to Vienna, she worked as an associate attorney for several large California law firms, did a lot of practical work there, in particular in complex construction and government contract disputes, and served as an extern for judges at the U.S. District Court for the Central District of Illinois and as a law clerk for the U.S. Attorney Office in the Central District of Illinois during law school. Her focus, in particular, since she moved to Vienna, is IP and IT law. She has been doing quite a lot of important groundbreaking research in many European research projects together with us, with a specific concentration on data protection, privacy, and platform regulation. And this is also one of the reasons why she is so well equipped to do this together with us today here. Katerina, thank you so much for coming. Thank you for accepting this invitation. The reason why we are doing this in this week is that the US Supreme Court will have its oral hearings on the cases we will be discussing in a second next week. So it's now the right moment to debate on this. Thank you so much for coming. Let us start with a very brief question, and a simple question perhaps also, which is, why are we meeting today? Katerina, what is the reason? What are the cases?
Thanks for having me. So we're going to be talking about two cases. They're both very factually similar, but one of the two cases, Gonzalez, which will be heard by the Supreme Court, as you said, next week, I believe, on the 21st, has to deal with a really, really important section called Section 230 and we'll talk about what Section 230 does, but in a word, it basically protects internet platforms for the publication of third-party content. So, again, we'll talk about the details later on that. But shall I just jump into the facts already of the two cases?
If you would, as you wish, Katerina. Perhaps also about the law. I just screened the law at the moment, so as you prefer.
Okay.
Go ahead.
Okay. So yeah, let's talk about Section 230 then itself. All right. So Section 230. We can talk about its history, but basically, it does exactly what we talked about. So let's read the actual law, and then we can maybe discuss a bit about the background of how it came to be. So it shields platforms for hosting the content of third-party providers or of third parties that could be harmful or could be actionable, the content itself. So the statute reads, no provider or user of an interactive computer service shall be treated as the publisher or speaker of any information provided by another information content provider. So that contains basically three components. So the first one is that you have to be a provider or user of an interactive computer service. Two, that the plaintiff's complaint has to treat you as a publisher or speaker. And the third one is that the information has to be provided by a third person. Yeah, another information content provider. So we'll talk about the cases at issue take issue with two of those three components mostly. Okay, so the second part of the statute, so part 2, C2, deals with, it's called a Good Samaritan. So basically what it says is that it's not just the hosting function of the websites that we're protecting, but we also don't want to incentivize websites basically not to, or platforms not to monitor content in any way or not to edit it in any way for fear of then being considered an editor or a contributor because they're trying to protect the users, or they're trying to limit kind of harmful content, right? So that's what number 2 does. It says you don't get to impute liability on a host, on a platform, on a hosting website, simply because that website attempts to in some way limit the harm or take down harmful content. So what we're concerned about in Gonzalez is really the first part of Section 230, the hosting itself, and not the editorial bit of it.
Okay, and this comes from the 90s, right? This is also something which is also worth being to be noticed, right? So this is very early internet regulation.
Exactly. Yeah. So so Section 230 was written in 1999, and in 1999, basically the internet looked very differently than it does today. Where we had a lot of just kind of bulletin board situations happening, where content, we didn't have this advertising structure that we do now, where content is curated and moderated and recommendations are made. This sort of targeting that we see today, and the advertising, basically social media as a phenomenon grew because of Section 230. Section 230 is what allowed it to become social media websites to become what they are today. So the case that inspired enactment of Section 230 was a case in which a defamation case, basically, in which a New York court held liable a website that for actually I think it was for an investment banking website or some sort of a securities website, but it basically held it liable because it said that this website did try to take down specific types of content, and the New York court said, well, since you are doing this kind of editorial function, since you are deciding which content to leave up and take down, you're not simply acting as a conduit. You are making content decisions, and therefore it held the platform liable. Congress said, well, this really creates some perverse incentives here, right? Because you're holding this website liable, even though it's trying to do the right thing, because it's making some kind of editorial decision about what content to leave up and what to take down. So it enacted Section 230, which essentially was meant to prevent exactly this kind of thing from happening. Section 230 also, the authors of it were cognizant about the fact that websites don't have the same knowledge, right? Or you can't impute the same kind of knowledge to websites that you would maybe to a traditional publisher, because of simply the volume of information that exists on a website. So saying that a website has actual knowledge, or even imputing knowledge to a website because it may have received one notice in the 1 million that it gets a day, well, it doesn't make sense. So that's what originally Section 230 was meant to target.
Yeah, what you're telling me here at the moment, Katerina, very much sounds like what we hear in Europe when it comes to an explanation coming from the European Commission about why the e-commerce directive was introduced and why the liability privileges of the e-commerce directive were introduced, and why they would need to be changed now by the Digital Services Act. So very much like the same story, which is in the 90s, the internet looked very different. And the liability privileges from the e-commerce directive, just like Section 230, were a precondition for platforms to develop. Platforms have developed. The internet looks very different now. So we need a new form of regulating the internet and regulating platforms. Exactly. I mean, in Europe, interestingly, this time we are in some way ahead of the US by the DSA, right? Exactly. And interestingly, but quite similar to what we see perhaps now in the US, also the European development was very much driven by courts, by the Court of Justice of the European Union in a series of cases and decisions on trying to apply the liability privileges of the e-commerce directive a little bit differently than in the 90s. And my question now is, why is the Supreme Court now the driver in this, and what exactly is the role of the Supreme Court in this debate, and in how far has the situation of the Supreme Court possibly changed in the last month or years on that matter?
Yeah, well, the Supreme Court has pretty much denied to grant cert to Section 230 cases in the past. So its position has changed in that it suddenly has decided that, well, this is the right platform on which, to hear these cases. And actually, I want to mention one thing about Section 230 that I forgot to, and that's pretty important for our conversation. So Section 230 is not, it doesn't cover everything. So there is still liability that websites can be charged with. So websites can still be charged with violating federal criminal law, intellectual property law, and certain privacy laws. So they can't invoke Section 230 if it's one of those items that we're talking about.
Yeah, here it is.
Yeah, and that's the case even if the alleged violations arise from publishing third-party content. And then in 2018, Congress added the sex trafficking offenses to those specified exclusions, and we might talk about that a little bit more later. Yeah. So in the past, the court has denied cert, and it's interesting that they've accepted cert here because oftentimes usually the court will only grant certification on a question of federal interpretation of federal law when there's a circuit split. So in the U.S., we talked about kind of how we didn't talk about it too much yet, but so there are three kind of levels of federal courts. There are the district courts, there are the circuits, which is several states together, and then there's the Supreme Court. And unless the circuits disagree about how to interpret a federal law, generally the Supreme Court won't take that issue up.
And the Supreme Court is completely free in the decision whether or not to take something up, which is also, this is not standard in Europe, right? So
for sure. Well, so yes and no, yeah. So the Supreme Court actually, in most cases, yes. There are a very small handful of cases in which the Supreme Court has what is called original jurisdiction, where a case will be filed directly with the Supreme Court. And those are cases like where states have conflicts, state against state. In some rare diplomatic, so very similar, where diplomacy issues arise. Yes, it's a very limited number of cases. I don't have them memorized off the top of my head, but in practicality, it's usually state versus state or United States versus state, where the court will have original jurisdiction. So so usually, yes. The court is free to grant certification to any case that comes up from the lands from circuit courts. Yes, the short answer is yes, and they actually grant cert only to like 100, I think, or 150 a year. I think they get something somewhere along the lines of 7,000 plus cases, applications. So it is kind of curious that they've decided to grant cert here. In the past, only one of, I think, the justices on the court has been vocal about wanting to talk about Section 230 again. And that's
Justice Thomas, right? Thomas, right?
Exactly. Yeah, exactly. And yeah, you might know what he's said. And this Thomas finds himself sort of in a curious position, right? Because I think the traditional arguments of the conservatives have been really pro-business, right? And Justice Thomas's arguments, it was specifically in a dissent. He wrote in a dissent to an opinion which denied certification, actually, which the court denied certification. And it was a really interesting opinion, and he basically says that, look, the internet has changed dramatically since 1996 when the law was enacted, and the sort of gist of it was we don't feel good anymore about big tech companies influencing our behavior through recommendations and through these algorithms, and the motivation behind basically these algorithms, a lot of them is earning extra advertising dollars and keeping us on the website for longer. But he set forth several really interesting arguments, which are traditionally not pro-business, and they have not been advanced by the political right in the U.S. So it's interesting to see how that's going to go.
Yeah. So the court is completely free to decide on whether or not to accept the case, and if they accept the case, and if they were now of the opinion that Thomas is right with his argumentation, so that the internet changed and that Section 230 needs to be interpreted differently than it was interpreted in the 90s, what would be the consequence? What would be the outcome then?
So once they accept cert, which they have in this case?
Yeah.
So when they accept certification, then the next steps are that the parties have X number of days to to submit briefs to the court. And I think they have to be under 50 pages. And then if all the parties agree, then what are called friends of the court, so amici curiae, can submit briefs as well.
Which happened quite a lot in those cases, right? So there's plenty of people being interested in the matter. So it's impressive. It's an impressive list of amicus curiae briefs. Yeah.
There have been an extraordinary amount in Gonzalez submitted. An extraordinary amount. And
just to share this with everyone. So this is what you see here, right?
Really impressive. So much less in Tumna, because in that case, Section 230 is not squarely at issue. But it's really impressive. And typically you don't get so many. It's quite common to receive amici curiae briefs in cases, but this is really extraordinary.
And the purpose of this is to convince the court, right? So everyone writing here tries to convince the court.
So everybody writing either tries to convince the court on one side or the other, or they have something important to say that they want the court to consider. So usually amici curiae will write on behalf supporting one of the parties. In this case, it's overwhelmingly in favor, and we should talk about the facts a little bit.
Absolutely.
But in this case, it's overwhelmingly in support of Google, YouTube. So in support of upholding Section 230 as it currently is articulated or interpreted.
But Katerina, before we talk about the facts, which is obviously important, let me also ask about why are they so concerned? So why are there so many amicus curiae briefs here? What would be? What is the threat? What could happen?
So we talked a little bit about this, but Section 230 basically allowed the internet to develop as we know it today. And depending on, what the court holds, it could have really far-reaching consequences on the entire economic model of hosting platforms, specifically social media platforms, but really, any website, because websites use these targeting and recommendation algorithms to sort and to organize and to display third-party content to users. And that's basically what's at stake.
But I'm sorry. I know that, and I'm not so much into the business model. I'm more about the legal consequences. So if the court comes to the opinion that Section 230 needs to be interpreted differently or needs to be interpreted in this or that way, is this legally binding? And if so, under which conditions? What would be the outcome for Section 230? What could the legislator do? So is all this written in stone? And in how far does it have an impact apart from the decision in this very single case?
Gotcha. Okay. So the Supreme Court only is the final kind of arbiter of the interpretation of constitutional law. So that's not what we have here. Here we have a federal law. And that means that if the court rules that Section 230 should be interpreted to exclude these kind of targeting recommendation algorithms, right? That it doesn't shield them from liability. Then tomorrow, or whenever the court rules, right? Tomorrow, Section 230 would no longer protect hosting platforms, would no longer protect websites that use these recommendation algorithms from liability under Section 230. But because it's a federal law, Congress can essentially legislate around that. It can just pass another law that says, well, great, Supreme Court, we're going to write another law that explicitly permits these sort of these sort of targeting algorithms to continue existing. So it's not quite, there are a lot of amici curiae briefs that present here a doomsday scenario, and if the court did take a very extreme position, which is really unlikely that it will, Congress can easily fix this by simply passing a new law. Like, yes, of course, it's going to take some time to do this, and there's going to have to be broad agreement about the contents of this new law, but there's a fix.
Okay. Okay.
I hope that's answered a bit better.
Absolutely, but at the same time, it's also very interesting for me as a European here that the court, on the one hand, is so free to decide on what to accept and what not to accept, and on the other hand, I mean, this doomsday scenario, meaning that on the day after everything changes, is impressive, right? And in particular, when you consider also how judges make their way into the Supreme Court and how political the appointment is, all this is. This is very interesting. But let's talk a little bit about the facts, if you don't mind. So what are the cases about, and why are they so relevant here?
Yeah.
And why are there so many people concerned about them?
Yeah, sure. Okay, so lots of questions there, but let's start maybe with the facts. So I'll start talking about Gonzalez first, because that's the case that we're kind of more concerned about here with Section 230. So Gonzalez is, there's an American student who was studying in Paris in 2015. And tragically, she died as a result of an ISIS murderous rampage that occurred during 2015. Now, plaintiffs in that case, which are the estate of the student, so her parents, allege that YouTube made it possible for these attacks to happen. And for these individuals who carried out the attacks to become radicalized, because what YouTube did was to recommend to these murderers, to these extremists that carried out this murderous rampage, to recommend ISIS created videos that were intended to radicalize people that watched them, and encouraged carrying out attacks in their home countries. Now, in Gonzalez, we don't have any facts that actually show that that's what happened, and that these videos were the reason why the perpetrators carried out the murders that they did. So why the terrorist attacks happened. There's not a very clean causal link here. But that's the basic gist of it. And the plaintiff focuses a lot on the fact that YouTube was actively recommending these ISIS videos to the terrorists. So that's Gonzalez. So Tumna is really, really similar, but there Section 230 doesn't come up. There, basically, the plaintiffs allege that it was under the Anti-Terrorism Act. So very similar, but here we have it's Tumna versus Twitter, and here the question is whether this kind of widely available service that Twitter basically gave terrorists a platform, whether this could be considered to be having aided and abetted or knowingly provided substantial assistance to the terrorists. Yeah. And there it was the relatives of Narwas al-Saf and he was a victim of the 2017 ISIS attack in a Turkish nightclub in Istanbul. Yeah. So very common tragic facts, that everybody agrees are awful, but it's curious that the court chose this specific factual setup in which to consider Section 230.
Yeah, I mean, this is in my view in very ways very interesting. First, I would assume that the recommendation systems of YouTube and Twitter are not identical, and everything on the platform is different. So it's already interesting to see that they are put into the same box here in a way, Twitter and YouTube. And second, it's also interesting that in both cases, it's rather extreme what has happened from a factual point. I mean, there isn't I mean, terrorism is probably one of the most emotional things one can imagine. And obviously, this is not really a case where people can sit together and try to rationalize the issue if terrorism is at stake. So my question is this a coincidence? I mean, are both things, first that it's YouTube and Twitter, and second that it's about terrorism, is this a coincidence or is this strategically planned? And if so, by whom?
Yeah. So for the first question regarding the YouTube and Twitter selection, so I think that was pretty random. I mean, they're really major platforms, right? Other than that, I don't think that this was intended that these two platforms are selected. And it's important to note that in YouTube, their recommendation algorithm is at issue, whereas for Twitter, it's not really the recommendation algorithm that's at issue, because the plaintiffs there are really concerned about the Anti-Terrorism Act and whether an aiding and abetting happened. So we're almost kind of skirting the issue of 230 altogether there, which is why Gonzalez is kind of more relevant for our purposes, since Section 230 is really what we want to talk about. Obviously, Tumna is going to have implications for the outcome of Gonzalez, and if the court holds in Tumna that aiding and abetting that defendants can't be held liable, then Gonzalez is moot. So that's one way that the court can kind of easily escape even dealing with Section 230 in Gonzalez. Now, whether the facts, I think the facts are telling. I don't know. I can't predict how, though. I'm really curious to see how, because I don't think it's a coincidence that the court chose something. So it's a harm that's so dramatic that nobody's going to disagree with the fact that these are not the kind of messages that we want these platforms to be transmitting and encouraging and highlighting, or I mean, they're sensational facts, right? And I think they were selected because of the fact that they are sensational. So only 4 of the justices have to agree to take up a case to grant cert. I think it's 4. Please don't quote me on that. I think it's 4. No, Thomas is probably one of them. We don't know who the other 3 are. But I think that the justices that did agree, I think they want a case in which nobody's going to take issue with nobody's going to take issue with the fact that the content itself was bad. So I don't really know what that says about which direction they're going to go. But it certainly has something, it certainly is telling about the fact that perhaps the court is going to be willing to limit 230 on a sliding scale based on how harmful it perceives content to be. That's been done in federal laws before, but it would be interesting, because that would really, there is no kind of content value judgment contained in Section 230, right? So explicitly saying that, I think in the opinion, isn't going to be something that the court's going to do.
Yeah. So I mean, let's assume that you are right, that they will try to slide a little bit about Section 230. I mean, the outcome of this for companies running those platforms would be that they would suddenly need to implement this, and it would probably quite quickly lead to some kind of filtering algorithms or filtering machines that would be used, and that would obviously trigger a lot of constitutional questions, which are very intensely debated in Europe: freedom of speech, freedom of information, data protection, and so on, so on. That I would assume that this would also be the consequence then in the US, and could that lead them to another constitutional follow-up case, or what would, or I mean, could somebody start arguing then that Section 230 is unconstitutional in this interpretation, and would that be a liable argument?
I mean, it sort of depends on what how exactly they decide to interpret Section 230. There are other cases. I think we'll talk about this a bit later, but there's a Florida and a Texas state law that raises First Amendment issues, and those are sort of separate. But there is a very long history of jurisprudence that Thomas actually mentions in his opinion in the dissent, that applies to common carriers. And that is essentially, that says that common carriers like television or telecommunications providers have the right to speak, and choosing which content to publish and which content not to publish, or which content to allow on their platform and which content not to allow on their platform, is a form of speech that's protected by the First Amendment. There are limitations to that speech that Congress has imposed, but the analogies between, and that's a legacy that I'm not incredibly familiar with, so I don't want to really go down that path, but there are some issues to drawing analogies there. But even in that common carrier kind of legacy of jurisprudence, we still have seen Congress being able to put limitations on that, and forcing broadcasting services to carry specific content in a limited context.
Okay, and will this play a role next week when the oral hearings are going to happen? I mean, what would we expect there to happen? How is this going to be discussed?
I think the court purposefully bifurcated those issues, so I think they're going to consider that in a separate. I think they're going to consider that separately under the First Amendment. I think here they really want to focus on whether Section 230 shields these kind of recommendation and targeting algorithms. I think the First Amendment question is separate, because that has to do not so much with an attempt of platforms to target or to edit, and whether that kind of brings them within or without Section 230. So the First Amendment cases have to do more with whether a platform chooses to leave content up or take it down altogether, and whether that's a protected choice. So that's a very different question. And I think the court won't want to mix the two. And I think it is really easy to mix the two, but I think here they really want to focus on the content of Section 230. And interestingly, we said before that the court is kind of the final arbiter of the constitutional language itself. So the First Amendment is such a law. And what the court says regarding the First Amendment there won't really be reversible in Congress. In that Congress is not going to be able to then pass a law that undercuts the Supreme Court's interpretation regarding the First Amendment.
Yeah, so that will have quite some impact if it should happen. Obviously,
absolutely.
Yeah.
Yeah, absolutely. So yeah, so I expect oral arguments to be really focused on kind of, well, where do we draw the line? I think the plaintiffs are going to face a lot of pushback on how do you distinguish YouTube's algorithm that recommends this third-party material and then that sorts it from basically what Google does. Because
or any other provider is doing, right? So
exactly. I mean, and there are really interesting questions there because, and the amici curiae have written a couple of briefs, addressing these issues. So they try to draw this distinction in the briefing about, okay, YouTube is acting more as a marketer rather than a publisher because they're pushing content, and it's not that users are requesting it. But the line there, I mean, how do you draw a principled line there? When somebody searches for a video on YouTube, aren't they searching for content? How attenuated does it have to be then to be considered a recommendation? That's classifying algorithms in that way is a task that there isn't really a principled way of categorizing them that the plaintiffs have articulated there. So I think it's a interesting question.
Yeah, and what do you think that will happen there next week? I mean, it's interesting because it brings together economical arguments, it brings together technical arguments, and finally legal arguments. And if I were a judge, which I'm not, and there are good reasons why I'm not a judge, but if I were one, I would have an issue in identifying all the expertise that would be needed to analyze this from a technical and an economical perspective in order to find the right legal conclusions. So how is this going to happen next week? I mean, is it realistic that a judge who is in his 60s or 70s has a proper understanding of how the internet has developed and will be developing, and what the impact of such a decision on the internet might be? And will there be any people advising them, or is it just that they read the amicus curiae briefs and they believe it or don't, right? How do you think that this is going to happen?
Yeah, I mean, so of course, exactly what you pointed out. I think the amici curiae briefs really are meant to try to make the judges aware of the vast impact that their decision can have. And of course, the judges do have clerks that, are presumably quite young, and not that age really has anything to do with it, but
no, it's more about all the things that you are doing apart from surfing the internet, right? So
True. I doubt many of the justices are on TikTok. Yeah. Well, I may be wrong. Who knows?
Yeah.
But yeah, I think that most of the justices are really going to be concerned about it's a good question. It's a really overwhelming task because it does have so many implications, both economic, both for speech, both for basically the way that the internet as we know it works. And especially, these social media websites can really change the face of how social media websites interact with their users. I don't know that all the amici curiae briefs in the world could predict exactly what kind of effects the court's ruling will have. But
But again, I mean, if it's so unclear what the effects might be, perhaps this is part of the agenda, and that brings me back to the beginning of this question, which is, I mean, there is also a political agenda here, obviously. So deciding on this case or not deciding on this case has an impact in any case on how the internet looks like. And if you have a certain political agenda in order to reform how the internet looks like, and no matter how it should look then, but it should look different from today, it's quite consequent and quite easy to understand that you take such a case, right? And if you are a little bit afraid about the consequences, and there are people who say that might change everything and it might have negative impact on freedom of speech and so on, then you would probably simply not accept the case, right? So the very fact that you are accepting something like this might already be an indicator of some kind of agenda behind that. And the question then would be whether this is the majority's agenda and whether you think that this is already something one can predict what's going to happen there.
Yeah, I completely agree. I don't think that any of us can really predict what the court's going to do. I don't think it's going to be as sweeping of a change as some of the briefs suggest, or some of the doomsday scenarios suggest. Simply because I think the justices they're obviously all brilliant and well aware of the fact that any kind of pivot like that could have really, really sweeping effects. So with respect to, I want to speak to the politically motivated issue that you raised, which is that part of this began with the fact that the former president of the US and others were using these platforms to tweet basically falsehoods and really incendiary, controversial things. And Twitter decided that it was no longer going to allow falsehoods about COVID, and it wasn't going to allow these inaccuracies, shall we say, to remain on its platform. And that is what incited Florida and Texas to pass the laws that they did in a very kind of quick manner. But so this is why we are seeing now conservatives calling for platforms like Twitter and all of these big platforms to be neutral about what kind of content they decide to take down. It goes a bit beyond that, but that's the politically kind of motivated aspect of why suddenly you see these conservatives supporting a more business unfriendly approach, to content moderation, because generally the political right, their entire the position of the political right is that we should let businesses do as they please, and the government has no business telling businesses what to do and how to moderate their content, and that free speech, or that the First Amendment protects their free speech. So now we're seeing kind of a change there, and Thomas is the example here.
Yeah.
I think there were a couple of other questions that maybe I forgot.
Oh, but about whether you could predict about the majority in this case, but that's probably you told me already that you couldn't, right? So it's unclear. The outcome is unclear.
I think it's tough. It's tough to I think it's tough to make any kind of predictions, because really only Thomas is the one that's articulated anything clearly about how he would rule. Kavanaugh has also written an opinion, but that's a bit different. That has more to do with the common carrier. That has to do with net neutrality. So that's a bit of a different position, but that his position there might kind of lock him in to not really being able to say that these recommendation algorithms can be can be considered speech, basically can be considered not as publishing content. So that's a little bit more attenuated. I can look for exactly what he had said in that case, but basically, he was when he was a judge on the DC circuit. So he wrote this opinion in a case it was about internet service providers. So we talked about it was a net neutrality case, and it was called U.S. Telecom versus the FCC. So in that case, he said that platforms like YouTube, that they have a First Amendment right to exclude the speech they don't want to carry. And he left himself an out because he said that there could be an exception if the government could make out a competition claim, or can say that there's so much concentration of power in the hands of a small number of platforms, it becomes a trigger for state intervention. So he said that he basically said that ISPs have a First Amendment right to exert editorial control over the content that they convey. So if he pivots now with 230, that might tie him in. He did.
Would he be? I mean, if he had said something about 230 somewhere before this case, would that be binding in the sense that he couldn't have changed his opinion? He could have, right? No.
Yeah,
so there is no self-binding effect of opinions written by judges, right? They can change their opinions.
They can change their opinions. Yeah, he can change his opinion. It's just more of a how
psychological argument, right? You don't do that if you're
Exactly.
justice at the Supreme Court. You normally don't do that. You change your opinion.
Exactly.
Yeah. So what would you expect then to happen next week, Katerina? I mean, which questions will be asked? How is this going to be, to be seen? How is it going to be perceived? Will there be any indicators about the opinions coming out of the questions asked? Is it possible to follow this live? So many questions.
Yeah, I think that now the Supreme Court oral arguments are broadcast live, if I'm not mistaken.
Yeah, I think so too.
It will be pretty exciting to hear what is going to be said. I think it's really hard to predict. I mean, we can go over, if you want, it might take a little bit of time, but we can go over the main arguments of both parties.
Please go.
And then we can maybe speculate about some questions that might be asked by the court, maybe even as we're doing it, as we're going over the positions. So maybe we can put up section 230, the first part, section C1.
Yes, I will do so in a second. Give me a second. So here we go. Here we go. And now we go up.
Because Gonzalez's argument is really technical. It's kind of based on the actual language of the statute. And their arguments are in some ways quite, we'll see as we go through them. So Gonzalez, the petitioner says that when YouTube recommends a third-party material, it isn't acting as a publisher. And it says that because the first argument is that the recommendation contains content that can be said to have originated by YouTube itself, so that YouTube actually authored. Okay, I'm going to backtrack really quickly because I want to mention that in this case, the government actually submitted an amici curiae brief. So, and they are one of the only ones that take the side of petitioner, of Gonzalez here. So they support Gonzalez. And they make a similar argument in that they say that YouTube's sorting algorithm is an implicit statement by YouTube that this content is in some way useful to the user, to the viewer. By making the recommendation that they're actually publishing something. That's the first original, that they're publishing original content. That's the first argument. So the problem here is that they're blurring the line between content and the platform's underlying structure or code, right? Because YouTube isn't going and writing in anything that's particular to these ISIS videos. That's just the way that the platform is structured. Okay? So number two, they say that because by recommending content, YouTube is acting more like a marketer or an advertiser rather than a publisher. And that by publishing content, by recommending this, by pushing content on the user, rather than letting the user request the content his or herself, that YouTube doesn't meet Section 230's definition of an interactive computer service. And that's because an interactive computer service is defined as a service that allows users to quote unquote access. material, and they really focus on that word access. All right. Yeah. So basically, the argument is that Section 230 isn't available for material that the website itself created, and that somehow that this recommendation algorithm doesn't qualify.
Yeah.
So I think really the big questions that the question the court is going to ask plaintiffs is, okay, what is the principal distinction then? What is the line that you draw between hosting, between organize? So Section 230 also says later on that organizing, deciding what kind of content to publish and not publish. So all these kind of editorial or publishing decisions, they all are protected. So the court's going to ask plaintiffs here in Gonzalez, okay, well, how does this recommendation algorithm differ from these kind of editorial decisions? And that's going to be really important, right? That's going to be the main. I think that's where the justices are going to focus their most of their effort. It's trying to get plaintiffs to pin down where's the line drawn. Yeah, I mean, I think plaintiffs are going to say that the main objective in pushing the recommended videos, and this is almost more of a not really written in their brief, but almost underlying what's being actually plaintiffs did right, is the main objective in pushing these recommended videos isn't to disseminate the third-party information. Rather, it's really to keep users on the website through their recommendations.
Of course.
Yeah. And so the effectiveness of the recommendation itself is what the platforms care about, and that they have a financial incentive in this because then they can get more advertising dollars. And I guess we didn't really talk about how the way that the YouTube's algorithm works, but basically, I think everybody already knows that the longer somebody spends on YouTube, the more likely that they are to see ads, and therefore, and that's how YouTube makes money, through their advertisements. So YouTube's business structure is such that they want users to spend the longest amount of time possible on their websites.
This is perhaps different from Twitter, by the way. This is why I was asking before about whether it's a coincidence that Twitter is the second one here, because Twitter probably does not have. I mean, Twitter also wants to keep you on the platform, but they don't really care too much about whether you read this tweet or that tweet, just provided that you are just staying on the platform. Yeah. Because you get advertisements, whatever you do there, right? And whichever tweet you're watching, right? So there might be a difference here.
Yeah, it's possible. I mean, I haven't really studied Twitter's business model, but I mean, YouTube doesn't really care about the videos that you watch, right? In that it doesn't care about the content. It wants to give you videos that it thinks that not. So when I say thinks, this is all the algorithm, right? Yeah. And this is part of the problem that we're talking about, is because you can't really attribute knowledge or motive to something that's inanimate. But so YouTube wants to give you videos that it thinks will make you stay on the website for a longer period of time. And, so I think this is the unspoken sort of, this is part of the unspoken, I guess, theme of plaintiff's brief. But the problem is that this doesn't really address the issue of, this is more going towards motive. This isn't based on the actual text of 230. Just because we feel kind of icky about what a website's or what a platform's main motivation is, that doesn't really affect what the letter of the law is, or what section specifically says. So they're going to have a hard time kind of skirting that issue, I think.
I mean, at the same time, this is also interesting from a methodological point of view, because I mean, you were very much, and many of the briefs are very much, and also the debate is very much about the text of this, right? Which is 25 years old. And I mean, as we said at the very beginning, the internet looked very different 25 years ago. And something which is a provider today is very different from what was a provider when YouTube was invented or Google was invented. And it's striking how much, however, people debate about the words and about the wording here. Isn't that strange? I mean, wouldn't it be much more useful to talk about the fundamental issues here, which is, as I said, is a platform different if it's using algorithms trying to be attractive to the users from platforms not doing this? This is, in my view, the question, right? So in how far is the business model changing the liability or not? And I'm not sure whether this can be found in the words. It's more substantial, fundamental, purpose related, what I'm searching for here at the moment. Wouldn't you agree?
Yeah, absolutely. I mean, that is obviously the more interesting question, right? And I think the reason that the parties in the court are sort of really don't want to get into that and the underlying motives is because, well, that's not the jurisdiction of the court in the US system, right? That's something that the legislature needs to consider. And it's the legislator's role to consider if the structure of the internet and you know, what we see today with social media platforms having such a monopoly over public discourse, you know, whether advertently or inadvertently, and oftentimes inadvertently, right? Whether that is okay and whether we need to reconsider that is a question for the legislature. And so the Supreme Court is allowed to look at the history of Section 230 and the history and the context in which it was passed. And that's something that that the Supreme Court is supposed to do, looking at the original intent. And in this case, actually, we have the two original authors of 230 who also submitted an amici curiae brief in support of Google and YouTube, because they say that these algorithms are you know, very well recognized descendants of what the statute. Exactly. It was originally intended to protect. But it is a very interesting question. Whether we still think that Section 230 does what it should have done then. The briefs really do they go to a lot of pain to try to draw these analogies between a traditional print media and publisher and a website. And frankly, so much of those analogies just you can't make those analogies anymore, because websites and print media have become simply the volume of information that a traditional publisher would have to deal with versus a website, you know, especially one of these very large websites, vlogs. The sheer volume makes it a completely different situation. You know, so it's interesting that we try to draw so many analogies still, that the parties are trying to draw, you know.
This is striking to me because I followed the debate already 25 years ago, and already then it was completely outdated to do all these analogies, and it's coming again, right? And this is really bizarre. I think it has a lot to do with the age of the people arguing here, right? Because if everyone were 20 here, the argument would look very different, I think, right?
Sure. I mean, but it's also it's again, you know, we're not legislators, so it's not something that we do have to rely on some kind of precedent. And publishing, you know, the print publisher is, I guess, the best we have at this point. And that's kind of the problem, is we are faced with a situation that's new, and that's the case with any kind of new technology, especially on this scale. And as a result, you know, we have to draw analogies with something that's familiar, that's comfortable and familiar. That's we can't just wave our hands and say, well, this just doesn't feel right because look at all the, you know, the negative consequences that it can have.
Yeah, but again, I mean, the court could have decided not to take the cases, right? So it's already the very fact that somebody or some of them decided on taking it means that they have an idea about how this has changed or should change since the 90s, right? And I find this a little bit concerning, I would say, right? In particular, when you look into how the Supreme Court has changed in the last years in quite some significant areas. Abortion, for example. I mean, this might be another example, right, where something which is written in stone suddenly disappears, right? And this might be, I mean, it's very different, obviously, but again, it looks like somebody has an agenda here.
Absolutely. It does. I mean, the composition of the court, as you know, really changed. I think these political appointments of the justices, that's something that's pretty new. And, you know, that's started happening in the last decades. In the past, justices were really, whether they supported one political party or another, or whether they tended to lean left or right, was not as an important consideration as apparently it has become in the latest appointment.
Okay, Katerina. So I think it's more than an hour now that we have been talking about this, and we will certainly discuss a lot more about this in a week when the oral hearings have passed. It's on the 22nd. If anyone wants to watch this, it's on the 21st. Sorry, 21st, Tuesday, February the 21st. It's going to happen. So we will have a lot to talk about after that, I'm quite sure. Is there anything that we missed so far that you want to talk about today? Is there anything important that we haven't covered yet?
No, I don't think so. I mean, there are so many arguments and so many stakeholders in this. It's really impossible to summarize all of the arguments. But obviously 230 is a really important piece of legislation, and I'm excited to see what questions are posed to both parties and how the court decides.
Yeah, we will see in the near future. Thank you so much for helping us to understand this today, Katerina. Thank you to those of you who listen to us. Please stay in touch with us, stay interested, and in particular, stay as healthy or become as healthy as you can as quickly as possible. All the best to all of you, and bye-bye.